Thank you very much. Please be seated. Thank you. This is the time set for oral argument in First United Four Corners, our cause number 1CA-CV 150377. Let's begin with introduction of counsel for the appellant.
Good morning, Your Honors. Jeff Shumway for the appellant.
Good morning, Your Honors. My name is Mike Catlett. I'm with the law firm of Quarles & Brady. I have my colleague Julia Kessner here at counsel table with me, and I represent the plaintiff appellee First United Funding, LLC.
Thank you both very much. Let me go through a few preliminaries. First, each side has 20 minutes, and if the appellant would like to reserve time for rebuttal, when you go to the lectern, if you'd let us know how much time you'd like to reserve for rebuttal, we'll try and not poach on it, so you'll actually end up with that rebuttal time. Second, we have reviewed the briefs, reviewed pertinent portions of the record. We've conferenced the case. We're familiar with the issues and the arguments you have raised, so you might wish to take that into account in your remarks today. Third, we are recording the proceedings today, both audio and video, and the video will be on our website in a few days, and you can also download it or look at it on YouTube. So when you go to the lectern, if I haven't already mentioned this, please restate your name, so if someone listens to it rather than watches it, they'll know who is speaking. And so with those preliminaries out of the way, let's go ahead and begin.
Good morning, Your Honors. Jeff Shumway for the appellants. I would like to reserve a little time, 5 minutes. I'll do my best to watch the clock. Your Honor, I am well aware of the adage that says that the client who has an attorney, that the client who represents himself as an attorney has a fool for a client. I'm willing to amend that to say that both the lawyer and the client are fools. I am, however, stuck in this position. I have tried to step back from this and look at what the real issues are and how to resolve them. It seems to me that the first issue is the granting of the motion for summary judgment. The court relied exclusively on a factual assertion in the answer that was erroneous and was later corrected.
But Mr. Shumway, we only review what was before the Superior Court at the time it issued its ruling, and at the time it granted partial summary judgment, all it had in front of it was the answer, which repeatedly acknowledged it was a modification, and we know that statements in a pleading are admissible against the party as proof of the facts that were admitted. And so we look at what the court had in front of it, and that's what it had.
That's correct, Your Honor, but I don't think it changes the analysis, because what a contract says isn't open to factual determination. It is a question of law.
We're not looking at what the contract says. We're looking at what was this. I mean, the answer couldn't have been more specific in repeatedly acknowledging it was a loan modification of the 2007 loan. So that's not the language of the contract or what it says.
I agree, Your Honor. The answer was erroneous. It was changed in a later declaration that was before the court at the time that the motion for summary judgment was decided. I believe that response was a supplemental response filed in early 2013, and I believe it's document number 140, but I'm not 100% certain. But, Your Honor, our argument is that the court had an obligation to look at the documents. And the reason is you can't interpret the meaning of a document unless you look at that document. Now, in this instance, the complaint attached the 2007 loan documents, but didn't attach the 2008 loan documents. We believe there were a couple of reasons for that. The first reason was that I had told the receiver in January of 2010 that I didn't have...
Record?
Yes.
Okay. Where is this in the record about what you said to the receiver?
I believe it's in the second declaration I filed, again in that in the SIR response. And so the receiver knew we didn't have documents. The other thing that wasn't disclosed, because they didn't...
But let me take you back, because you got 56F relief So why didn't you pursue the discovery on that? Judge Gama gave you 120 extra days to pursue all the discovery you needed. I'm not sure why what you're saying now is something to lay at the feet of the appellees.
We actually did pursue discovery. So, for example, we took the deposition of both representatives of the receiver. When asked if they were aware of any other fraud committed by Corey Johnson, they said, no, we're only aware that it's alleged that he signed one other document. That was a knowingly false statement. It turns out that Mr. Johnson, we had to go, none of what you saw was disclosed to us. We had to go searching state by state by state.
But we need to go back. We're getting all over the map, and I think what you started by talking about was the motion for partial summary judgment and what the court had in front of it at the time it granted it. You had not challenged the authenticity of the documents. You had not challenged any or made any forgery allegations at the time that motion was granted. And so I'm trying to focus you on what Judge Gama had in front of him at the time he granted the motion, because that's all we're going to look at.
Well, Your Honor, then we were unaware of all those facts. That's why they were alleged in a second declaration. They had not been disclosed. We were not told about them. And in fact, we believe they were hidden, which is why the 2008 loan documents were not attached to the complaint.
Well, but let me ask you, the answer, as Judge Downing has indicated, indicates that the 2008 loan documents were modifications. There's no allegation that, well, we don't have them, so we can't fairly answer what they are. And the trial judge then relied on that, judicial admission in reaching its conclusion on summary judgment. I guess I'm struggling with why a lack of disclosure with respect to the 2008 documents would create such mischief.
Your Honor, because if they had been attached to the complaint, we would have had them and read them. And
fair enough, but you didn't have to say they were a modification, yet you did.
well, the lawyers representing us at the time did that.
And that's a really important distinction. I appreciate it. That's very, very fair, and I rounded off too much at the corner. But that responsive pleading, which courts rely on with good reason, took the position it was a modification, not we haven't seen the documents, not it was something completely different. It's hard, again, for me to see why the trial court improperly then relied on that statement.
Well, because that's a statement of fact, Your Honor, and the document says what the document says.
And I understand that, but can a party tell the court how it construes or considers the document? And isn't that what that answer does?
Yes and yes, but the court, we believe, has an obligation to review the document and decide as a matter of law what that document says.
But you're saying you didn't have the document when you filed that answer, yet you're expecting the court to have looked at that document before it ruled. Am I understanding that correctly?
Yes, but I believe the documents were before the court, Your Honor, and I believe they were They are contained, Your Honor, in Plaintiff First United Funding's separate controversy statement of facts and supplemental statement of facts.
And does that document say, oh, and by the way, court, don't look at our answer because it's wrong?
It doesn't, Your Honor.
Okay.
At the time we filed these, we were unaware of the extent of the fraud or even that it involved us.
But again, with respect to the 2008 documents, you had them then, so you knew whether they were a modification or they weren't, right?
And we said they were not.
Well, but you didn't
in our supplemental filings before the decision was made.
But you didn't amend your answer to correct that.
We did eventually, Your Honor.
But after the ruling, correct?
Yes, but the court did an interesting thing in that regard. It took the amended complaint and gave it great weight, allowing them to bring, for example, new claims for unjust enrichment against one of the other parties. But the court put no weight and, in fact, did not even acknowledge that we had filed an amended answer. If we have shown that the loan agreements were before the court had an obligation to take a look at them and rule as a matter of law whether or not they said what the plaintiffs alleged they had said. And we haven't even touched on the fact that, is it okay to make an allegation in a complaint that you know isn't true based on the documents? And it isn't. And so the court made a decision based solely on an answer that had been repudiated in a separate declaration after the fact, and eventually an amended answer.
But, you know, we're talking about modification, but the 2007 guarantee that you signed applied to any extension or renewal or substitution. And so it didn't have to be a modification. A substitution seems to be well supported by the record because the existing balance from 2007 was split into two notes in 2008, substituting the 2007 obligation.
Well, Your Honor, if you look at the 2008 documents, you'll see that the loan agreements in those documents required title insurance to put that deed of trust for Facility 1 in first position.
But it was the same existing deed of trust from the 2007 transaction.
No, it was a brand new deed of trust, Your Honor.
For the 2008?
For 2008, there were two new deeds of trust. One of them is a forgery. One of them has the wrong signature page attached to it.
Okay, well, let's get back to the 2007 guarantee that you signed because it applies to any extension, renewal, or substitution. So you're saying it's none of those, it's not a modification, so
that guarantee is inoperative. The law is when it's paid off, the deed of trust is of no force and effect. But what is a substitution? A substitution is, hey, Mr. Shumway, we found typographical errors in the note you signed. Here's one with those errors corrected. Please sign it. We're going to substitute it for the one that we originally had. That's a substitution. A payoff, which is reflected in the record, is completely different. When it's paid off, as we allege in our amended answer, then the deed of trust goes away.
I want to get back to something you said because I'm not sure I understand the same from the record. And again, I'm focusing you only on what Judge Gama had when it ruled. In your SIR reply, I don't see any of the allegations you're saying you made later in the amended answer. So in other words, I don't see where you put in front of Judge Gama before he ruled on partial summary judgment the issues of fraud, authenticity, et cetera. And so maybe in your rebuttal you can point me to the specific record site where you did that before he ruled on partial summary judgment.
I will take a look for that, and hopefully I have the document, Your Honor. But for purposes of this argument, Your Honor, we'll put aside the authentication issue. Because even if the 2007 deed of trust is authentic, and even if the 2008 two deeds of trust are authentic, the 2007 deed of trust is not a modification. Now, the parties knew how to do a modification because they did one of the 2008 loan. And that modification very clearly, in bold capital letters, says loan modification agreement. That is at tab 4 of First United Funding's supplemental appendix at Exhibit 4. So they knew how to do a modification. Nowhere in the record is there any argument, either at the trial court or at this court, that the 2008 loan documents actually say that they're a modification. The argument is that we made a mistake our answer. That's true. A mistake was made. We tried to rectify it. We eventually filed an amended complaint. The court, with amended complaint before it, with amended factual allegations, should have looked to the note, should have actually read the document.
It had already granted partial summary judgment at that point.
It had, Your Honor.
So it was supposed to sua sponte, go back and undo it?
No, I believe we asked him to. And we filed our counterclaims. So the entire linchpin of this comes down to one thing. If you say in your answer, yes, it's a modification, and there is nothing in the documents anywhere that support that, and there's nothing in the documents anywhere that support the original allegation that it was a modification, does that one admission that was later changed mean that the court can completely ignore its duty to resolve the question as a matter of law? And we believe the answer is no. The court has a duty to look at the documents and resolve the question. Interestingly, I believe, if our answer had said something outrageous like the contract required that $1 million be delivered to our front yard on December 31st, the First United would be arguing, court, you have to look at the document and see what it says. Well, of course you do. You can't make that jump as a matter of law that the document says something that it clearly doesn't say.
Isn't there a difference, though, between an admission in a pleading and a self-serving statement in a pleading, in how you treat it?
Well, Your Honor, I don't think so. I mean, allegations...
Doesn't the rules of evidence treat those differently?
Well, you're entitled to answer the complaint, which we did. We made an error. We filed an amended answer, and the amended answer should be the operative document.
Of course, that's after the court ruled. Judge Downey's made that point multiple times.
We understand that,
No.
Your Honor. And so, but essentially, here's what we're facing. There was a mistake. The mistake was based on a false allegation in the complaint that was not supported by the documents. And because of that mistake, the court's not going to look at the actual document to determine what it says. Now, that has some pretty severe consequences, including to the guarantor and including to the lender. But it also completely requires, if the court comes down on that side, then the motivation is to do exactly what these plaintiffs did. Make an allegation unsupported, don't attach the documents, and hope that they don't get found out. That's what happened. And now the question is whether or not, as a matter of law, that document actually says what they alleged it said. And it doesn't. And they don't even argue that it does. Your Honor, I'm running out of time rapidly. A couple of quick things. There's a waiver argument that we waived. First of all, the loan documents were not signed by the guarantor. The loan agreement was not signed, and it only waived rescission and damages. It didn't waive fraud. And if you look at the guarantee, it only waived the borrower's defenses. And the best example is bankruptcy. It says that if a debt's forgiven in bankruptcy, that's a defense for the borrower, and the guarantor cannot assert that defense. But certainly, the guarantor can assert other defenses where they're not specifically waived. I'm going to try to reserve the last bit of my 4 minutes, Your Honor, and look for something. Thank you.
Good morning, Your Honors. Again, my name is Mike Catlett. I'm from the law firm of Quarles and Brady. And while in name I represent First United Funding, LLC, my real client, for lack of a better term, is Lighthouse Management Group. Lighthouse Management Group was the receiver that was appointed to oversee the assets and operations of First United Funding by a Minnesota trial court in 2009, after it was discovered that Mr. Johnston was operating a Ponzi scheme whereby he would oversell participations in the loans he was making. One of the things that the Minnesota trial court authorized my client to do was to investigate who had received monies from First United Funding, borrowers and guarantors, and to pursue lawsuits against them on the notes and guarantees and other loan documents. This is one such case. Before I move into the issue of the 2007 versus the 2008 loan documents, as I pointed out in a notice of supplemental authority that I filed a few weeks ago, this particular panel's job has been significantly streamlined by an unpublished opinion that was issued by a prior panel of this court, and Judge Norris was a member of that panel, rejecting much of what the Mr. Shumway argues in this appeal.
I think that's persuasive authority. It's certainly not binding. It's not an opinion. It's not the same parties. But I have a bone to pick with whoever requested 54B certification of these judgments. We've now had piecemeal litigation with the La Jolla matter, with this matter, and then we've got Greta Shumway as a third appeal. So whoever requested 54B, that's on you.
Well, that's my fault, Your Honor.
No, but I'm saying it in jest to some extent, except it is frustrating because the purpose of 54B is not to have the kind of piecemeal appeals that we've had now.
And I understand, and the reason I did it was that I didn't suspect that the fair market value issues with respect to Four Corners would be as simple as they were with La Jolla, because there were issues about my client turning around and selling the property at a particular price. So I thought that was going to drag on for a while, and because it was a separate, La Jolla is a separate loan, separate parties, that it would just, my client was entitled to pursue that loan first. But I understand that it creates additional work for all of you, and I apologize for that.
I do think it's only, you said law of the case, but it's not really law of the case. It's a different node, it's different parties, and so we look to it for persuasive value, but I don't think you should rest too much on that other opinion, although Judge Norris was on it, so I'm sure it's excellent.
Well, it's different. The borrowers are different. The personal guarantor is not. And I think more importantly, it arises from the same motion for summary judgment below that Judge Gama decided. And if you look at that motion, Mr. Shumway didn't parse out his arguments. This argument applies to La Jolla. This argument applies to Four Corners. So it's generally the same issues, and the same goes for our motion to dismiss the counterclaims that were filed later on by Mr. Shumway. The two unique issues, though, are this issue having to do with the 2007 loan documents and the 2008 loan documents, and then the wrongful foreclosure counterclaim that sort of stems from that issue that was brought by Four Corners in the counterclaim. So I just want to walk the court through the progression of what happened with respect to the motion for summary judgment and this issue of the loan documents. So my client, when it got involved in this situation in 2010, sent two notices of default to Four Corners and Mr. Shumway. The first said, we believe you've defaulted on the 2008 loan documents and we intend to enforce our rights thereunder. The second one, 3 months later, said you've also defaulted under the 2007 loan documents and we intend to enforce our rights thereunder. My client then notices a trustee sale, publicly records the notice of trustee sale. That document makes it abundantly clear that the deed of trust that my client was foreclosing on was the 2007 deed of trust, not the 2008 deeds of trust that I don't think were ever even executed. There's some discussion in the records about there being a 2008 deed of trust, but for whatever reason, the parties, First United Funding and Mr. Shumway and Four Corners, never recorded those documents. So my client moved on the 2007 deed of trust.
Can I back up for 1 second? Because I asked Mr. Shumway that question, and I may misapprehend the record. The only deed of trust I could find in the record was the 2007 recorded deed of trust, and that's why I asked him, wasn't it the same deed of trust that was applying to the 2008 transaction? I do not, and I strongly do not believe that the drafts of the 2008 deeds of trust that were never executed or recorded are anywhere in the record. I don't believe they were ever attached to a filing by Mr. Shumway, and certainly not before Judge Gama made his summary judgment ruling. So my client forecloses or records the notice of trustee sale, making it clear that what we're moving on is the 2007 deed of trust. Neither Mr. Shumway nor Four Corners attempts to challenge that notice prior to the trustee sale, and the trustee sale occurs. We then file our complaint, and in the complaint we make clear that Four Corners and Mr. Shumway signed both 2007 and 2008 loan documents. We then, within a few months, move for summary judgment. Oh, I'm sorry. Mr. Shumway answers, and again admits that the 2008 loan docs are a modification. That was an allegation that we had affirmatively made in our complaint. And Mr. Shumway responds, says, yes, it is a modification, and then repeatedly refers himself to that loan as the 2008 loan modification. We file for summary judgment. We again incorporate that language and in our separate statement of facts, call it a loan modification, and say that the 2008 loan modified the 2007 loan. Mr. Shumway files a substantive response to our motion for summary judgment.
And in that response, he says again that it was a loan modification. In his summary judgment response itself, he refers to it as a modification. And in his controverting statement of facts, he refers to the 2008 loan as a modification.
Do you have the paragraph number?
Not in front of me, I don't, Your Honor. Well,
That's
I do.
okay.
I do on the substantive response,
Okay.
actually.
Okay.
I have a cite to our appendix for you. It's in our appendix. It's tab 7, and you can see the reference to the 2008 loan as, quote, Four Corners loan modification at pages 6, 7, and 11 of that filing. So alternatively, in their response, after referring to the 2008 loan as a, quote, modification, Mr. Shumway alternatively requests 56F relief. Judge Gama grants that relief and gives the parties 120 days to conduct discovery. I, at that point, had no clue that I was supposed to conduct discovery as to whether this was a modification or wasn't a modification, because I had in front of me multiple admissions by my defendants saying that it was a modification. So no discovery was done on that particular issue. And then Mr. Shumway files a supplemental response. And in the first paragraph of that supplemental response, even incorporates by reference his prior summary judgment response that referred to this as a loan modification. Now, he did, in that supplemental response, for the first time make this argument that actually it wasn't a modification, it was a payoff. And so at that point, we filed a supplemental reply, and Judge Gama then ruled on the issue, saying that I have these admissions from the plaintiff, or I'm sorry, the defendant, saying that this is a modification. And above and beyond that, he didn't just rely on that admission and say I'm granting summary judgment. He said, I've also looked at the facts and the documents here, and this, no one disputes that the one loan was just a payoff of the other. And so therefore, at the very least, it's a substitution or a replacement or a renewal. And there was, as Judge Downey pointed out, there was plenty of evidence in the record to support that finding. There was, the loans, the 2007 and 2008 loans involved both the same borrower and lender. The 2007 and 2008 loans involved generally the same amounts being lent. The 2007 and 2008 loans involved the same security document, the 2007 deed of trust. And if you look at the case law, including there's a Court of Appeals Division 2 case from 2011 called Continental Lighting, in footnote 3 of that decision, it discusses what the difference is between a modification and a replacement. And it says a modification occurs where the original security document remains in place. A replacement occurs when you have another deed of trust that is recorded that then replaces the original deed of trust. Under either scenario, though, it's our position that the 2007 guarantee would still be applicable, because even if there had been the 2008 deed of trust that Mr. Shumway claims should have been recorded and wasn't, we don't know why, it would still only be a replacement, which would then cover mean that the 2007 guarantee remain inoperable. And I want to talk quickly about what the scope of that issue is. So on the 2007 and 2008, the difference between those loan documents, I think that it has two sort of corollary issues that result from that finding. One is, what is the scope of Mr. Shumway's personal guarantee? There's no dispute that he signed a 2007 guarantee that we've referred to that we say still remained in place even after the 2008 transaction. There's also no dispute that he signed a guarantee in 2008 for $575,000. So the loan was split into two. There was a $1.3 million portion, and there's a $575,000 portion. Mr. Shumway doesn't dispute that he signed a personal guarantee to cover at least $575,000. The issue then becomes, well, like I said, did the 2007 personal guarantee cover everything, even after the 2008 transaction? We think that Judge Gama was correct, that the answer is yes. One, because of the admissions that had been made by the defendants, and two, because if you look at the law and the facts at issue here, this was clearly at the very least a replacement which is covered under the plain terms of the 2007 guarantee. The second issue that arises because of this issue with the 07 and 08 documents is the foreclosure claim, or the wrongful foreclosure counterclaim. And again, with respect to the scope of that issue, I would point out that all Mr. Shumway ever did with respect to that issue is bring a counterclaim. So it doesn't affect our affirmative claims for breach of contract against Four Corners. It only means that at the most, I guess, if he were successful on that claim, he would have some sort of set-off against what he owes Four Corners, the $1.8 million. But as we point out, both below and in our papers, Mr. Shumway has an issue with 33811C. And that statute says that if you're going to challenge the trustee sale, you need to seek and obtain a preliminary injunction prior to the trustee sale occurring.
And that statute's been construed fairly broadly as any claims dependent on the sale, correct?
Correct. And if you look at Madison versus Groseth, which is a case from a couple of years ago from this court, the court said it applies to tort claims that are based on an objection to the trustee sale. And I don't know how much more clearly you can have a claim based on an objection to the trustee sale than a claim that you've titled as wrongful foreclosure in your counterclaim. So it's our position, and Judge Gama, we believe, correctly concluded that 33811C bars that wrongful foreclosure counterclaim. And I would point out that in Mr. Shumway's opening brief before this court, he makes no mention whatsoever of that issue. So it's our position that he's waived any objection to Judge Gama's conclusion that 33811C bars that counterclaim. Moving beyond that, however, as we point out, no court in Arizona has ever even recognized a claim for wrongful foreclosure. I recently searched the case law. I didn't see that that has changed in the intervening few months that this appeal has been pending. Finally, you have the issue, again, is similar to the issue on the personal guarantee, because the 2007 deed of trust that we clearly notified Mr. Shumway that we were foreclosing on. So there wasn't any trickery here. We publicly recorded the deed of trust that said, this is the deed of trust we're moving on. That deed of trust, again, says that it applies to any modifications, substitutions, or renewals. And for the same reasons that I gave earlier, the 2008 loan, we believe, was a modification. The defendants admitted that it was a modification, both in their answer and in their original summary judgment papers before Judge Gama. And as a matter of fact, we believe that the record fully supported Judge Gama's conclusion that it was a modification. Now, I suppose if Mr. Shumway wanted to challenge Judge Gama's reliance on his judicial admission based on either record evidence that he had submitted later or a change in his answer to the complaint, he could have done that, but he never did.
Well, and I think I asked Mr. Shumway, was somewhat jokingly, was Judge Gama supposed to sua sponte remember they had granted partial summary judgment and go back and undo it himself? And he said, no, we brought it to his attention. What, other than the answer and counterclaim, brought that to Judge Gama's attention? Was there a motion for a new trial from the grant of partial summary judgment on that basis? There was
as best
much later.
Much later in 2015, yes, so you're talking about 2 years later. The best I can recall, Mr. Shumway opposed our motion for entry of judgment. And in that opposition was the first time he attached some of these other pleadings he's now relying upon that my client had filed against Jerry Moyse up in Minnesota, claiming that Mr. Moyse aided and abetted the Ponzi scheme. So there's that. And then later on, I believe Mr. Shumway moved to vacate the judgment and made similar arguments, but he hasn't, on the entry of judgment, he has generally challenged, I guess, the judgment in this case, but he hasn't pointed specifically to that motion and say or argue that Judge Gama abused his discretion in any way in denying it. And with respect to the motion to vacate the judgment, there's never been any appeal at all from that ruling. So I think what's before this court is the summary judgment ruling and the motion to dismiss ruling.
Could you briefly address the dismissal of the RICO counterclaim? It's a strange procedural circumstance that a Rule 12b-6 motion would be brought after a motion for partial summary judgment that Judge Gama relied on in part as a basis for dismissing the RICO counterclaim. Setting aside the continuity argument, which I'm not totally on board with, what's your best argument for why it was proper to dismiss it under a 12b standard?
So there's two. He didn't properly plead that it was a pattern of racketeering activity. For the same reasons that his other claims fail, and that is his basis for saying or alleging that you committed fraud against me was that you fraudulently foreclosed on this 2008 deed of trust when you weren't allowed to. We've already gone over that multiple times here. And his second argument was, well, you didn't disclose the Ponzi scheme to me, and that was fraud. And so there's two instances there. But as Judge Gama held, and as we pointed out here in appeal, First United Funding, as a matter of law, didn't have an obligation to disclose to Mr. Shumway where it was obtaining its funds to loan to Mr. Shumway on the loans. And there's no evidence in the record, and it wasn't pled with particularity either, that the nature of the relationship between First United Funding and its borrowers generally, or with respect to Mr. Shumway specifically, was such that First United Funding would have known that Mr. Shumway would expect that we would say, oh, well, here's where we're getting this money. This was a pretty simple transaction.
Isn't there an easier way? Judge Gama gave several bases for his dismissal of the RICO counterclaim, and the reason I referred to the procedural anomalies here is it seems like one of the bases was, I've already ruled as a matter of law on partial summary judgment that they got everything they were legally entitled to in this transaction, and that's another basis for saying, as a matter of law, no causation.
Right. And that's I hadn't gotten there yet. Sorry, I was being long-winded on pattern.
Okay. I wasn't seeing the connection yet.
Yeah, so that's one element. The third reason that Judge Gama gave was causation or damages. Again, there's been no showing, or there wasn't even an allegation in the counterclaim that the Ponzi scheme, or failing to disclose the Ponzi scheme, had actually resulted in any damage to the defendants. As I was about to say, this is a very simple transaction. We loan you it started with $1.3 million for a period of time, and you give us a piece of land, raw land, as security, and at the end of the time that's indicated in the loan documents, you have to pay that money back to us with interest. That didn't occur. The payback didn't occur, and so we proceeded with the foreclosure sale, and we're pursuing the deficiency. There's no evidence in the record or no allegation that the Ponzi scheme had any effect whatsoever on Mr. Shumway and Four Corners' ability to repay the loan. And so that was the basis of Judge Gama's dismissal of the civil RICO counterclaim, and we think that was a correct ruling. And it was also subject to the prior appeal, and I understand there are issues with whether that was law of the case or not, but the prior panel affirmed the dismissal of the civil RICO counterclaim on similar grounds.
Is there any evidence in the record, or perhaps argument in the record, that when First United made the loan, there was some type of anticipation that additional loans would be extended? My point is on causation. If this was just a straight, we're going to loan you $1.7 million, you're going to pledge the real property, go and take that $1.7 million and do whatever it is you want to do with it. That's one thing. Versus, we're going to loan you $1.7 million, and we're going to be your ongoing lender of choice. Is there an argument that there was the latter type of relationship versus the former?
I don't believe there is any evidence supporting that that was the nature of the relationship at the time that the loan was made. There certainly wasn't any evidence like that in front of Judge Gama when he made his summary judgment ruling. And off the top of my head, there may have been an allegation in the answer and counterclaim that Mr. Shumway later on had an expectation that maybe these loans would be rolled over in one-year time periods moving forward. But again, there was nothing in the loan documents that would have required us to do that. There's no email traffic between Mr. Shumway and my client indicating that that was the expectation. And so anything that is, alludes to that later on, we think would just be, self-serving allegation that Mr. Shumway made well after the rulings that are pertinent in front of you this morning. And if there are no further questions, I'd respectfully request that you affirm the judgment and award my client its attorney's fees and costs on appeal. Thank you very much.
To answer Judge Downey's question, on October 2nd, 2012, index of record number 76 is the defendant's supplemental response to plaintiff's motion for partial summary judgment and counter motion for summary judgment on the claims, along with a separate statement of facts which contains my second declaration. And that response, that supplemental response, lays out all of the arguments that we're concerned about here today.
Thank you. And I think actually Mr. Catlett sort of alerted me to that too, so thank you.
As to a couple other things, Mr. Catlett, he said, well, there were deeds of trust, but they weren't recorded and we don't know why. But you have to ask yourself, why were there deeds of trust? There were deeds of trust because there were new loan documents. Those loan documents were before the judge. You now know that he had these arguments before him, and he simply chose to not look at them and decide that the one admission, which was later contravened by a declaration, was all he needed. But as a matter of law, the documents say what the documents say, and they're either a modification or they're not. And the law is pretty clear. You pay off the loan, and the evidence is quite overwhelming that this was a payoff. There's two new deeds of trust. There's escrow instructions.
Where are those two new deeds of trust in the record?
They are part of plaintiff's First United Funding's response to defendant's separate controverting statement of facts, which was filed on July 15th, 2011.
Okay, do you have the record number for that?
I can get it quickly.
And you're saying those two deeds of trust are attached to that?
Yes, they are exhibits to the declaration of Mark Allen.
Okay, thank you.
So on July 15th, 2011, it appears, Your Honor, that it would be,
I can find it. I've got the date.
I think it's about 31,
Okay,
30, 31, Your Honor. So we have all of these factual email. We have the title company saying sign the release. We have the lawyer saying sign the release. We have people saying, the title company saying, we have the lawyer telling the title company record the new deeds of trust. There really is no information and no evidence that these were modifications other than the erroneous admission, which was later corrected both in declaration and in the amendment. One of the things that kind of got breezed over regarding the guarantees, in a prior filing where they argued that there was no need to disclose any information to the fact that this was a criminal enterprise, here's how they ended up. The same clear rule should apply to a lender's duty to disclose information about its own financial condition. At most, a lender should only be required to do so when the lender is irretrievably insolvent. Now, Your Honor, they said that before we did our state-to-state search and found the declarations of Mark Allen that said that from the beginning, 2002, First United Funding was insolvent. So their own pleading, which is their IOR number 98, it's an October 29, 2012 supplemental reply, says that that needed to be disclosed, that they're insolvent. And the question is, was the guarantor exposed to risk that wasn't anticipated? And the answer to that question is clearly yes. And we know it because they sued Jerry Moyes, who was in exactly my same position, as a co-conspirator. We received stolen funds, which weren't disclosed. They were insolvent. And just real quickly.
How were you damaged? How did any of that cause you any damage?
Well,
I mean, you don't get free money just because the lender was operating at the time as a Ponzi scheme.
Well, no, but Your Honor, the law is not that if you got the money, that's the only inquiry. If that was true, we wouldn't even have
My question is,
fraudulent inducement.
I'm sorry, my question was more precise. How has that caused you any damage?
As the guarantor, I now have a nearly $3 million judgment against me that I would have never incurred had I known the truth about First United Funding.
So you are saying that you never would have borrowed money from that entity had you known that they were basically a Ponzi scheme?
Yes, and that is undisputed. It's in the record, Your Honor, and I've been exposed to potential criminal penalties.
But you did receive, or your entities received, the money. You received money. You have to pay it back. Someone gets it, and that's not you, is it?
I'm sorry?
I mean, you have a debt. You owe a debt.
Four Corners has a debt.
Okay, and you're saying it's okay for them because they're judgment proof, but you as a guarantor somehow get to avoid that.
If I was fraudulently induced, that's the law, yes. The law isn't, if you got the money, there's no further inquiry.
Inducement requires you to either accept the benefits of the contract or give the money back, so you don't just get to keep the money.
Well, as a guarantor, I never got the money. Four Corners got the money. Four Corners had its property foreclosed on. I never received the money.
But you can't both rely on fraudulent inducement as your sword, and then when it comes time to comply with the elements of fraudulent inducement, say, oh, not me.
Well,
You can't rely on fraudulent inducement and then disavow it.
well, I'm not disavowing it. What we said in our papers is that the court, under its equitable powers, has the ability to structure a remedy to address the situation where the deed of trust has already been foreclosed on. And the court does have that equitable power. Anyway, I have nothing further, Your Honor. Thank you for letting me go beyond the zeros.
Not a problem. Thank you both for your argument and your briefing. We're going to take this matter under advisement, and we will issue a decision in due course. We're going to recess so the bailiff can set the courtroom up for the next argument. Thank you both.